The studio lights glimmered harshly, casting sharp reflections across polished surfaces. Cameras hovered, red recording lights blinking steadily, signaling the start of something significant. A low hum of anticipation filled the room, the kind that makes every breath feel heavier, every movement magnified. On one side of the long table sat a man whose name alone carried decades of weight, Alan Dershowitz. Years in elite classrooms, countless Supreme Court arguments, famous clients, and a reputation that commanded respect, authority, and deference. Every posture, every gesture seemed to radiate the certainty of someone who had spent a lifetime mastering control. On the other side sat Congresswoman Jasmine Crockett. Unlike her opponent, she carried no aura of intimidating prestige. She didn't fidget. She didn't shuffle her papers to impress anyone. She didn't try to occupy the room with posture or voice. She simply sat, calm, composed, eyes focused, quietly analyzing every detail. A faint smile lingered on her lips, not arrogance, but awareness. She had seen men like this before, in courtrooms, boardrooms, and committee hearings, men who assumed confidence could replace preparation. Moments earlier, Dershowitz had walked onto the set, a thick stack of papers in his hand. His approach was deliberate, almost theatrical, a subtle signal to the audience and the cameras. He was prepared, he was certain, and tonight he would demonstrate his mastery. To him, this wasn't a debate, it was a lecture, and the assumptions in the room reflected that. An 85-year-old legal titan, decades of experience, versus a congresswoman barely 2 years into office. What could possibly go wrong? The narrative seemed pre-written, the outcome obvious, or so it seemed. Phones in the audience were already raised. Social media feeds were alive with speculation. Commentators whispered predictions. It's over before it starts, they said. And yet Crockett remained unshaken. She had no need for spectacle. She had her preparation, her knowledge, and an understanding that authority without scrutiny can be fragile. The real story, she knew, was in the details, in the human impact, in the facts that could not be waved away by credentials alone. The moderator cleared his throat, and the cameras zoomed in. He introduced the topic, voting rights. It was a subject loaded with history, emotion, and stakes far beyond the studio walls. Immediately, the energy shifted. This wasn't just another panel discussion. This was a collision of approaches, philosophies, and life experiences. Dershowitz spoke first, his voice smooth, controlled, polished with decades of academic training. He framed the debate as an examination of constitutional boundaries, federal authority, and the limits of congressional oversight. His words carried authority, laced with the subtle confidence of a man used to being the final word. The audience nodded. Some scribbled notes, others leaned in. Yet, as he spoke, Crockett's eyes didn't waver. She listened, absorbing every claim, every nuance. Her experience as a public defender had taught her to remain calm in the face of aggression, to recognize when an opponent was relying on style instead of substance. And that was precisely what she noticed now. The lecture tone, the reliance on reputation, the assumption that credentials alone could dominate the conversation. She waited. She didn't rush. Every pause, every word from Dershowitz became an opportunity to understand, not react. Her preparation wasn't about spectacle. It was about substance. It was about connecting constitutional theory with lived reality, the real-world consequences that often go unnoticed in elite legal debates. She knew that tonight the public wasn't just watching a debate, they were witnessing a test of clarity, integrity, and presence of mind. And so the stage was set. On one side, decades of experience, prestige, and a lifetime of teaching legal reasoning. On the other, youth, preparation, and a focus on reality over reputation. The assumptions were clear, the audience expectations defined. But as any experienced strategist knows, the most obvious outcomes often hide the biggest surprises. What happened next would not only challenge assumptions, but redefine how authority and preparation interact in the public eye. The cameras rolled, the lights glared, and the nation watched, unknowingly, the first moments of a debate that would soon capture attention far beyond the studio. As the debate moved forward, the contrast between the two sides became impossible to ignore. Alan Dershowitz leaned further into the role the room had already assigned him, the authority. His posture straightened, his voice carried the practiced cadence of a man who had spent decades commanding lecture halls. Every sentence seemed designed not just to argue a point, but to remind everyone listening who he was. Supreme Court cases, constitutional scholarship, a lifetime inside elite institutions. The message was subtle, but unmistakable. Experience outranks everything else. He spoke of voting rights as a legal puzzle, one to be solved through precedent, interpretation, and restraint. Federal intervention, he argued, was dangerous. States, he insisted, were the rightful guardians of their own elections. Congress, in his view, was crossing lines that the Constitution had carefully drawn. His language was technical, layered, and confident, the kind of delivery that often overwhelms rather than persuades. For many watching, it sounded convincing simply because it sounded authoritative. Across the table, Jasmine Crockett did not interrupt. She didn't nod in agreement, nor did she show disagreement. She listened, closely. Every claim he made, every case he referenced, every assumption embedded in his argument, she absorbed it all. This wasn't passive listening, it was strategic. Years as a public defender, I taught her something essential. The more someone talks from certainty, the more information they reveal. And information, when understood properly, becomes leverage. Dershowitz continued, subtly shifting from legal argument to intellectual dominance. He questioned how lawmakers without deep constitutional training could fully grasp the implications of such legislation. It wasn't an insult, not openly, but it was a dismissal, a suggestion that passion had replaced precision, that politics had overtaken law. The audience felt it. This was no longer just about policy, it was about hierarchy. Still, Crockett remained still. She had heard this tone before, in courtrooms where men in expensive suits assumed they could talk over her, in hearings where lived experience was treated as anecdotal rather than essential. She knew that reacting too early would only confirm the narrative being built around her, so she waited. Timing mattered. When she finally spoke, the shift was immediate. Her voice was steady, grounded, and deliberate. She didn't begin with theory. She didn't cite her resume. She started with people, with voters, with communities she had represented long before she ever stepped into Congress. She spoke of citizens who didn't experience voting rights as an abstract concept, but as something fragile, something that could disappear through paperwork, distance, or quiet policy changes. The room recalibrated. She acknowledged constitutional limits, not dismissing them, but framing them within purpose. The Constitution, she reminded viewers, was not written for scholars alone. It was written for the public. Its authority came not from interpretation alone, but from application, from whether its promises reached real people or remained trapped on paper. Dershowitz shifted in his chair. He responded quickly, tightening his argument. He cited Supreme Court rulings, Shelby County, federal overreach, state sovereignty. His words came faster now, sharper, as if speed itself could reassert control. He framed her comments as emotional, well-intentioned, but legally naive. Stories, he implied, could not override structure. Crockett didn't push back immediately. Instead, she did something unexpected. She acknowledged his points, calmly. Then she reframed them. Shelby County, she explained, wasn't just a case she had read about. It was a decision she had lived with. She had represented people whose access to the ballot changed overnight because of it. Her tone wasn't accusatory. It was explanatory. She wasn't attacking the law. She was exposing its consequences. The audience leaned in. For the first time, the debate began to feel less like a lecture and more like an examination, not of Crockett's understanding, but of Dershowitz's assumptions. The contrast sharpened. Theory versus reality, abstraction versus consequence. He scoffed lightly. Voter ID laws, he said, were common sense. Necessary, harmless, a reasonable safeguard. The phrase landed and lingered. Crockett's expression changed, just slightly. Not anger, focus. This was the opening she had been waiting for. She leaned forward, not aggressively, but intentionally. And instead of making a statement, she asked a question. A simple one, a human one. Had he ever represented someone who couldn't vote because they couldn't afford the documents required for an ID? Had he ever sat across from an elderly citizen with no birth certificate? A single parent unable to take time off work to visit an office open only during business hours? The room went quieter. Dershowitz didn't answer directly. And Crockett didn't let that moment pass. She spoke about the gap between legal theory and lived reality, about barriers that don't appear in casebooks but show up at ballot boxes, about how access isn't theoretical when it determines who gets heard and who disappears quietly from the process. Something had shifted. This was no longer about who had more credentials. It was about who understood the stakes. And for the first time, the audience could feel it. The balance of the room was starting to tilt. And then, just as that realization settled in, Crockett prepared to make a move that would change the debate entirely.
By this point, the rhythm of the conversation had changed. What began as a confident lecture was now something else entirely. The audience could feel it, even if they couldn't yet explain it. The room was quieter, not because fewer words were being spoken, but because more weight now sat behind every sentence. Jasmine Crockett had done something subtle but powerful. She had slowed the debate down, and in doing so, she had taken control of it. Alan Dershowitz sensed the shift. He adjusted in his chair, straightening his jacket, reclaiming posture. Experience had taught him that authority, when challenged, must be reasserted quickly. He returned to precedent, stacking cases one after another, layering legal language with precision. His tone sharpened. He emphasized restraint, warning that federal oversight, no matter how well-intentioned, risked destabilizing the constitutional balance. To him, this wasn't about denying access. It was about preserving order. Crockett listened. She didn't interrupt. She didn't rush to counter every claim. Instead, she waited for the argument to complete itself. Years in court had taught her that weak arguments often collapse under their own weight, if you let them. When she spoke again, it wasn't to challenge his authority. It was to examine his logic. She began by agreeing with him on one point. Constitutional structure mattered. Federalism mattered. Limits mattered. The acknowledgement disarmed the room. This wasn't opposition for opposition's sake. Then, carefully, she pivoted. Structure, she explained, only has meaning if it protects people equally. Otherwise, it becomes a shield for exclusion. She cited Article 1, Section 4. Calmly, plainly, Congress's authority over federal elections wasn't implied, it was written, not as an abstract power, but as a safeguard. She paired it with the enforcement clauses of the 14th and 15th Amendments. Again, not as lofty ideals, but as tools designed for moments exactly like this, moments when states failed to protect access. Dershowitz cut in. He reframed her argument as emotional. Lived experience, he suggested, risked clouding legal clarity. He warned of slippery slopes, of unintended consequences. His voice grew firmer, almost parental. The subtext was familiar. Passion must yield to expertise. Crockett didn't raise her voice. Instead, she narrowed the focus. She asked whether equal protection meant anything if it existed only on paper, whether access that disappeared in practice could still be defended in theory. The questions weren't accusatory, they were surgical. Each one forced the audience to sit with a contradiction. Then she did something unexpected. She referenced his own work. Not casually, not vaguely, specifically. She quoted from one of his books, written decades earlier, where he argued in favor of federal standards in states with documented histories of voter suppression. She used his words not to embarrass him, but to clarify the inconsistency. The professor froze, just for a moment. It was subtle, but the cameras caught it. She asked a simple question. Had the Constitution changed, or had his position? The silence that followed wasn't dramatic. It was heavy. Dershowitz attempted to recover, saying context mattered, times had changed, evidence had evolved. Crockett acknowledged that too. Then she asked the follow-up that tightened the frame even further. Had constitutional principles evolved as well? Now the tension was unmistakable. The moderator shifted in his seat. The audience leaned forward. This wasn't a theoretical debate. It was an examination of consistency, of credibility, of whether authority could withstand its own record. Dershowitz lent on experience again. He reminded viewers of his decades in classrooms, of shaping generations of legal minds, of standing before the Supreme Court time and again. Expertise mattered, he insisted. Constitutional law wasn't learned in a campaign. Crockett waited until he finished. Then she smiled, not warmly, not sarcastically, but precisely. The kind of expression a trial lawyer wears when the opening has finally appeared. She said she respected experience deeply, but she pointed out something uncomfortable. He was leaning on credentials instead of addressing her arguments. That approach might work in a lecture hall, she said, where students worry about grades. But this wasn't a classroom. This was public law, and the stakes weren't academic. The shift was now undeniable. Dershowitz bristled, accusing her of dredging up old quotes instead of focusing on present law. Crockett nodded. Then she explained why those quotes mattered. They revealed a pattern, a flexibility in interpretation that seemed to change with political outcomes. She referenced his recent legal arguments, not ancient history but modern positions, where he had argued that state legislatures could override the will of voters when appointing presidential electors, a position that if adopted could nullify millions of votes. She held up the document, his words, his reasoning. She asked how that argument aligned with his sudden devotion to state restraint. For the first time, he looked unsettled. The murmurs in the room grew louder. The balance had shifted. The debate was no longer about who knew the law better. It was about who was applying it honestly. And as that realization spread, one thing became clear. This wasn't the peak yet, because the question that truly exposed everything was still coming.
This was the moment the room stopped breathing. Not because voices were raised, not because anyone slammed a table, but because the dynamic, the invisible hierarchy that had framed the entire conversation, finally cracked. Jasmine Crockett didn't rush into it. She allowed the tension to stretch, just long enough for everyone watching to feel the weight of what was coming next. Alan Dershowitz was still speaking, but the energy had changed. His words carried less certainty now,
less command. He circled familiar ground: federalism, restraint, precedent, but the cadence was different, defensive, compressed, as if the argument was shrinking inward instead of expanding outward. Crockett waited until he finished. Then she leaned forward, not aggressively, not emotionally, intentionally. Her voice, when it came, was softer than before, calm, almost conversational, the kind of tone that signals confidence so deep it doesn't need volume. She didn't accuse him. She didn't challenge his intelligence. She didn't even restate her argument. She asked a single question. A question so simple it felt almost harmless at first. She asked whether the Constitution protects the right to vote or merely the procedure of voting. The air shifted. It wasn't a trick question. It wasn't framed to embarrass, but it forced a choice, and that choice mattered. Because if voting was only procedural, then barriers were just technicalities. But if it was a right, a fundamental one, then access could not be treated as incidental. Dershowitz paused. He began to answer by redefining the terms. Rights, he said, are always subject to regulation. No right is absolute. Free speech has limits. Due process has structure. Voting, he argued, was no different. Crockett didn't interrupt. When he finished, she followed up, gently. She asked whether those regulations are still constitutional when they disproportionately exclude specific groups, when they predictably silence communities with fewer resources, when the burden doesn't fall equally but consistently lands on the same people. The cameras caught it. For the first time, Dershowitz hesitated longer than usual. His response came slower, more cautious. He spoke about intent, about neutrality, about laws that apply to everyone equally on paper. Crockett nodded. Then she asked the question that changed everything. She asked whether a law that is neutral in language but discriminatory in effect can truly be called constitutional under the 14th Amendment. The room froze. This wasn't rhetorical. This was foundational. The Equal Protection Clause wasn't ambiguous here. Its entire purpose was to address laws that pretended to be neutral while producing unequal outcomes. Dershowitz tried to redirect. He said courts look for intent, that effect alone isn't enough. Crockett agreed, and then tightened the frame. She asked how intent is measured when lawmakers openly acknowledge partisan goals, when internal documents show awareness of racial impact, when courts themselves have recognized discriminatory outcomes but felt constrained by precedent. She wasn't arguing emotionally. She was building a legal box and slowly closing the lid. Then came the final move. She referenced his own public statements again, not aggressively, precisely. She reminded him that he had once argued that the Constitution must be interpreted not just by original meaning, but by its moral trajectory, by its purpose in expanding inclusion. Her question landed quietly. If that was true then, why was it not true now? There was no easy way out. If he said the Constitution was fixed, he contradicted his own scholarship. If he said it evolved, he undermined his argument against federal protection. Either answer weakened his position. The pause felt longer than it was. He spoke, but the answer lacked clarity. It was cautious, qualified, technical. And that's when the audience understood. This wasn't about winning a debate. It was about revealing a fault line. Crockett hadn't overpowered him. She hadn't shouted him down. She had simply asked the one question his framework couldn't fully absorb. The power dynamic flipped. The expert was now explaining himself to the lawmaker. The professor was responding to the public defender. Authority had shifted, not because of volume or credentials, but because of clarity. Crockett closed calmly. She said that constitutional law doesn't live in classrooms alone. It lives in communities, at polling places, in the quiet decisions people make when access becomes too hard. She said the Constitution's legitimacy depends on whether it protects participation, not just process. She leaned back, and she stopped talking. The silence that followed said everything. This was the moment viewers would replay, clip, share, debate, not because it was flashy, but because it exposed something deeper, the difference between guarding power and guarding democracy. And the conversation would never fully recover from it.
What happened next didn't stay inside the studio. Within hours of that exchange, the clip began spreading across social media platforms, legal forums, and political commentary shows. What initially looked like a routine debate had now become something far more unsettling for the establishment, a moment that exposed how fragile authority can be when it's challenged with facts instead of force. This wasn't about who spoke louder. It wasn't about theatrics or viral insults. It was about credibility and who truly owned it. For decades, legal scholars like Alan Dershowitz have operated from a position of assumed superiority. Their arguments often rely on technical language, historical references, and the expectation that the audience won't push back. But Jasmine Crockett did something different. She didn't challenge the law, she challenged the interpretation of power. Her question forced a shift. Suddenly, the conversation wasn't about abstract constitutional theory anymore. It was about real-world consequences, about who benefits from strict voting laws and who gets excluded, about whether the Constitution is a shield for democracy or a weapon used selectively. And that's when the discomfort became visible. You could see it in the pause, in the hesitation, in the way the answer tried to circle around the question instead of confronting it. Legal experts watching closely noted something critical. Dershowitz wasn't unprepared, he was boxed in. Any direct answer risked contradicting his own past positions. Any evasion made the power imbalance obvious. Crockett didn't need to raise her voice. The structure of the argument had already collapsed. This moment resonated because it broke a familiar pattern. Usually, when political debates happen on television, they follow a script. One side dominates with authority, the other reacts emotionally, and the audience picks a team. But this exchange refused to play by those rules. Crockett's approach was methodical, precise, and rooted in accountability. That's why the reaction was so intense. Supporters praised it as a masterclass in preparation. Critics tried to downplay it as a media moment. But neither side could deny one thing. The balance of power had shifted, even if only for a few minutes. And in politics, minutes matter. Voting rights advocates seized on the clip as proof that legal arguments alone aren't neutral. They're shaped by perspective, privilege, and lived experience. The debate stopped being about what the law says and became about who the law serves. Meanwhile, traditional commentators struggled to reframe the narrative. Some claimed the exchange was taken out of context. Others argued it was oversimplified. But those explanations didn't land because the question was still hanging in the air, unanswered. That's the danger of a well-placed question. You can argue with opinions, you can debate interpretations, but when someone forces you to confront your own record, your own words, and your own contradictions, there's nowhere left to hide. And audiences noticed. Viewership spiked, search trends surged, law students dissected the exchange in classrooms. Even seasoned analysts admitted that something unusual had happened. Not a viral clip, but a structural challenge to authority. This wasn't about embarrassing an individual. It was about exposing a system that often assumes expertise is unchallengeable. Crockett didn't reject expertise. She demanded responsibility from it. That distinction is crucial, because the most powerful moments in democratic discourse aren't loud confrontations. They're calm interruptions that reveal what everyone else has been ignoring. By the time the segment ended, the damage was already done, not to a reputation, but to an illusion. The illusion that legal certainty equals moral correctness. The illusion that history can't be questioned. The illusion that power explains itself. It doesn't. And sometimes all it takes is one question to remind everyone watching who democracy is really supposed to serve.
By the end of that exchange, something subtle but powerful had occurred. No gavel was struck, no verdict was delivered, and yet a judgment had already been made, not by a court, but by the public watching in real time. This wasn't a moment manufactured for clicks. It wasn't designed to humiliate or to score political points. It was the kind of moment that unsettles people, precisely because it feels authentic. A moment where the audience senses that the script has been abandoned and truth has stepped in. The question lingered. It followed the broadcast into living rooms, onto smartphones, into late-night conversations and morning commutes. People replayed it not because it was loud, but because it was precise, because it challenged a long-standing assumption that authority deserves deference simply because it exists. And that assumption cracked. For many viewers, this wasn't just about voting rights or constitutional law. It was about representation, about seeing someone speak from lived experience while still commanding the language of institutions that historically excluded voices like hers. That combination is rare and powerful. Jasmine Crockett didn't posture as a revolutionary. She positioned herself as a steward of accountability. She asked what the law means when it stops protecting everyone equally. And in doing so, she reframed the debate from legality to legitimacy. That shift matters more than any single policy, because laws can be amended, but legitimacy, once questioned, is much harder to restore. The aftermath revealed something deeper about modern political discourse. People aren't disengaged because they don't care. They're disengaged because too often debates feel detached from reality. This exchange cut through that detachment. It reminded viewers that questions, when asked with clarity and courage, can still disrupt entrenched narratives. Even critics who dismissed the moment couldn't fully erase its impact. Why? Because the clip didn't rely on context. It created its own. You didn't need a law degree to understand what was happening. You didn't need to choose a political side. All you needed was to recognize discomfort and ask why it was there. Discomfort is a signal. It tells us when familiar explanations no longer hold, when authority is being tested, when accountability is demanded, not deferred. That's why this moment became more than a viral exchange. It became a reference point, a reminder that democracy isn't just preserved through institutions, it's sustained through vigilance. And vigilance begins with questions. Not hostile ones, not performative ones, but honest questions that refuse to accept rehearsed answers. As the conversation around voting rights continues, this exchange will be remembered not for its personalities, but for its principle. The principle that power must explain itself, that expertise must answer to consequence, that democracy is strongest when no one is above being questioned. And maybe that's the real reason this moment resonated so widely. In an era saturated with noise, outrage, and spectacle, clarity felt radical. A single question, calmly delivered, cut through layers of assumption and revealed something raw beneath. Not a scandal, not a takedown, but a reckoning. So the next time you hear a confident voice explain why the system works as intended, remember this moment. Remember how quickly certainty can dissolve when confronted with reality. Because democracy doesn't collapse from chaos, it erodes when questions stop being asked. And sometimes all it takes to wake a nation is one question, asked at exactly the right moment.